there was one final case to refer the court to, which is the Blumenthal against Itochu case, also a Court of Appeal, which is in the Legal Authorities, Volume 2, tab 24. If I can just give the court the nub of the background facts. This was a dispute as to whether an arbitration clause required the appointment of a sole arbitrator or more than one arbitrator, so that 3 arbitrators were to be appointed. So an application was made under Section 18, which is quoted at paragraph 9 on page 598. An application was made under Section 18 for an order of the appointment of a sole arbitrator pursuant to Section 18(3)(d). And you'll see it gives the power to the court at page 598, paragraph 9, to make any necessary appointments itself. As we shall see, an order was made by Mr. Justice Andrew Smith appointing a sole arbitrator, i.e. the application under Section 18 was successful and he refused permission to appeal. Now, there were 2 relevant provisions of the 96 Act in play. You'll see also at paragraph 8, and it's quoted again, Section 15, because this is the provision which tells one how one is to approach the question of appointments. So you basically follow the normal principle of party consent, and in little 3, if there's no agreement as to the number of arbitrators, the tribunal shall consist of a sole arbitrator. So the court concluded that there was no agreement as to the number of arbitrators on the proper construction of the arbitration agreement, and therefore appointed a sole arbitrator. Now, Section 18 contains, as you'll see at paragraph 9, the same restrictions on appeals. The leave of the court is required for any appeal from a decision of the court under this section. Now, so just in terms of what the first instance judge, Mr. Justice Andrew Smith, as he then was, concluded at paragraph 10, you can see that at paragraph 10, he observed that the application gave rise to a short question under Section 15 as to whether Section 15(3) applied, despite the fact that the parties contemplated a tribunal of more than one arbitrator. So in other words, it referred to arbitrators, but didn't actually identify the number. So he concluded there was no agreement as to the number, and therefore 15(3) applied, and therefore he appointed a sole arbitrator under Section 18. So now, if you go to paragraph 20, so the question for the court was whether this was a decision. The order making the appointment was a decision under Section 18. And the argument was being run was that there was a threshold question under Section 15 as to the proper construction of the arbitration agreement, and that threshold question was not a decision for the purpose of Section 18. That was the argument, and therefore there was no restriction on appeal. That was the argument, because Section 15 contains no restriction. So paragraph 20, if we take that up at page 600, what the Court of Appeal, forgive me, Lord Justice Gross is saying here, at first blush, so he's answering the question, is this a decision? At first blush, it plainly was. The respondent's application was for an order. Itochu sought directions under Section 18(3) in the event the order was made in terms under Section 18(3)(d). If the first impression is well founded, this inevitably follows that we have no jurisdiction to entertain the appeal. And then you'll see the point at 21 about the threshold question, which was being raised in response under Section 15. And if you look at paragraph 22, right at the bottom, just above J, in my view, it follows from Verdi versus Verdi that a decision does not cease to be a decision under this section for the purpose of Section 18(5) merely because the judge is required to take into account another section. Now, if we then go on to paragraph 24, there's reference to the ASM decision, which we've already looked at. And what the conclusion on the conclusion of the court with respect to ASM shipping is at page 602, just above paragraph 25. Thus, the mere fact that the judge's decision was or might have been based on another section did not mean that it was not a decision under section 68. And 28, pulling the threads together, and this is the bit I rely on. So for my part, I see no reason to depart from my initial views. The judge's decision was in form and in substance a decision under section 18 caught by the restrictions on appeal provided by 18.5. No question of principle arose in relation to section 15. The sole question was whether on its true construction the arbitration clause came within section 15.3. Whatever view the judge took on that question, he had thereafter to take a decision under section 18.3. Now, pausing there, I submit that that's the key point of distinction in my respectful submission between our case and that. Because whatever view the court took under section 15, whether it's 1 or 3, it was bound thereafter to make to address the application for an order under section 18 and make the appointment or appointments. In my respectful submission, that's not the position here, because it would depend on the outcome of the section 73 application whether or not a decision would be made under section 67. So if one reads on, it says at little b, and this is again my point of emphasis, all roads led to a decision on the merits under section 18.3. There was no anterior or preliminary question which might preclude the court from taking a decision one way or the other under section 18.3.
Well, whatever view the judge took on the 73 point, he then had to go on to make a decision under section 67, although if he was in your favour, if he had been in your favour on section 73, that decision would not have determined the section 67 decision.
Yes.
Is that that's
I think
slightly more accurate, isn't it?
I'm sure that's slightly more accurate, but where I'm driving at, and your lordship may not be with me with this, what I'm driving at, it seems to, in my respectful submission, what the court is getting to is that the section 15 point would determine the section 18 application.
Yes.
Whereas in our case, the section 73 point will not determine the section 67 application. It will only determine it one way. If the section 73 application is rejected, there is a separate decision to be made.
Yes, I think that's what I was
trying
to
I
say.
apologise,
Probably not very clearly.
No.
But yes.
So that's the point of distinction that I seek to rely upon.
Yes, I see.
And apologies, my lord.
No, not.
And the only other point is if we look to the concurring opinion at paragraph, your lordships may or may not find this helpful, but if we go to paragraph 33, the concurring judgment at 33.1, the order made by Andrew Smith J was an order to appoint an arbitrator. Such orders are made under the power conferred by section 18. Such orders are made under that section. The provisions of section 15 were among the reasons. It's trial law that an appeal to this court on appeal against the order made by the court below, it's not appeal from the reasons it gave. Obviously, in Mr. Justice Butcher's order, to the extent that's relevant, on the preliminary issue, his answer is no. And so there's no order. under Section 67. And then Section 2 of the order is dismissed by reason of the summary judgment. So if one looks at it by analysis by reference to the order, which is the analysis being done here, in my submission, because the preliminary issue was answered no, there was no decision under Section 67. That's where,
Or at least the decision was separate.
the decision was separate.
Can we then reverse it? Just think about what the order would look like if you had been successful
Yes.
under Section 73.
So the answer to the preliminary objection would be yes, and the Section 67 application is dismissed.
Yes.
Is my respectful submission is how it would have read.
But would it, in a sense, would that be maybe this doesn't matter? Are you saying that would be a single provision in an order, or
I don't think it matters, my lady, whether it's you say that the reasons don't matter, but the application is dismissed. I think.
Well, we have what may be the atypical case here, because first of all, you wanted a summary determination of the Section 67 application, and secondly, you wanted a separate preliminary issue,
Yes.
on which therefore the judge had to make an order
Yes.
on Section 73.
Yes.
But if what might be the more typical case had taken its course, that is to say, the judge had dealt in one hearing on the merits with the Section 67 application, to which part of your defence had been that they'd lost the right to object because of Section 73, then the judge would simply have made a single order at the end of the hearing dismissing the Section 67 application. Now we know that he would have given permission to appeal. Well, perhaps he wouldn't at a final hearing, but suppose he had given permission to appeal to Mr. Bailey's side in order to challenge the dismissal on the merits of the Section 67 application. Would it have been open to you, and would you have needed leave to say that the judge's order should be maintained by way of respondent's notice on different and additional grounds, namely that he ought to have decided Section 73 in your favour?
So obviously, in my submission, even if it was drafted into in my submission, the way we're potentially getting into situations as to how one goes about drafting an order, and there are cases on that from the Court of Appeal as to how you go about. And forgive me, I haven't put them before the court, and your lordship will be more familiar. There is one which comes to mind, which Gordon Pollock argued before the Court of Appeal, because the Court of Appeal, if I remember rightly, said if it makes a difference in terms of what is the subject of appeal, it may be that the order has to be split up. So I'm not sure the premise, with great respect, that there would be a single order, and this is simply reasons, is potentially the correct analysis. I don't want to be I don't want to misstate the position, but I have the feeling that there could be an argument for me saying to the court, you've got to split up the orders because there are separate points in play here, and you can't just simply treat that as a reason, because the true reason for the dismissal is on the merits, and this is a separate point. But there are authorities on this point, and I apologise, I haven't. So I'm not sure I can answer the question in the way that you would like me to answer, other than to say in my submission the 73 would still.
I think I'd like you to answer it in one way or the other.
Well,
I'm just interested to
yes,
know.
no, it's a very interesting question, my lord. But I think the answer I would be giving, subject to that authorities, would be I would be inviting the court to make two separate orders because it reflected two distinct points, which. Yes.
But I don't see why you would be asking. I mean, if I understood it correctly, the postulated suggestion is that you have a single hearing at which you take your Section 73 point, and the Section 73 point is taken
Yes.
successfully, with the result that the Section 67 application is dismissed,
Yes.
what my lord put you was you would just have a dismissal of a Section 60.
No, I see.
So the other way round.
The
The
other
Section
way round.
73 application fails,
Yes, but the Section
it's dismissed on the
67
merits.
succeeded.
I don't see why you would want it to be.
Well, I wouldn't,
the
in
order
the
to
same
be
way that we didn't want to hear.
split into two separate paragraphs of the order, because then you would need to appeal. It would be a cross appeal, wouldn't it? Rather than just
Well,
upholding the.
and of course, it may depend on whether permission is granted on the dismissal of the Section 67.
Well, if permission's not granted on the dismissal, you don't need to appeal.
Correct.
But if permission is granted on the dismissal, you'd want to be in a position to
And
say,
Yes.
I want this
Yes.
dismissal upheld for a different reason.
Yes.
And I don't need to cross appeal or seek permission to appeal. I can just do it as a respondent's notice, seeking to uphold it for a different reason. But that, I think, might only be the case if you didn't have a separate paragraph in the order.
But if that is true, then it's exactly the posture I've taken here.
But here you have got a separate paragraph in the order, and you do need permission to appeal from somebody. The question is whether we can give it to you.
My, perhaps, simplistic position is it shouldn't turn on the form of order.
But I think it might do. I think there might be authority which says it does.
Well,
I
I think your lordship is right. There is authority on the point, but I also think that that I feel in a state of unease in misleading the court on this point.
No, understood. But undoubtedly, in the present case, you've got an order which answers the preliminary issue no.
Correct.
And you want to challenge that, and you need permission. The question we're debating is whether you can ask us for permission or whether you can only ask the judge. Yes.
I'm sorry.
All right, no, that's fine. Carry on.
Yes, I think I'm being reminded because it's the Sinoga case, but I mean, it's not going to assist you since I can't tell you what it stands for. Right.
I think the Sinoga case says that if you do have a separate paragraph in the order, then if you want to challenge that, you need a cross appeal.
Yes, it may well do that, but I also think that the same decision, there was criticism potentially of the first instance judge by trying to wrap it up all in one order,
Yes.
as opposed to two orders, because he wanted to avoid permission to, if I remember rightly, it was something along the lines that he wanted to avoid permission to be, it was in the context of a settlement agreement and a decision that, and he wanted to avoid permission to appeal being granted. And so he wrapped up a separate point within. Anyway, I'm sorry. I'm not helping the court at all.
Can I ask you this?
Yes.
We know that the judge made a decision on your preliminary issue because he answered it no.
Yes.
So the question is, was it made under Section 67
Yes.
or not? If it was not made under Section 67, what was it made under?
I say it was a decision under Section 73.
Well, Section 67, like some of the other sections in the Act, expressly says the court may do this and the court may do that.
Yes.
So it's quite clear if the court does one of these. Section 18, which you just showed us
Yes.
in the Itochu case as an example, the court may appoint an arbitrator. So if the court does appoint an arbitrator, it's obvious that it's doing it under Section 18.
Yes.
It's exercising a statutory power given by a particular section. Section 73 is not worded like that. It doesn't say the court may do anything. It simply says a party may lose the right to object if. So in what sense is the court making a decision under Section 73?
I take the point, my lord. But my point would remain that it doesn't become a decision for the purpose of Section 67(4) because it doesn't dispose of the application.
So Section 67 says the court may confirm the award, vary the award, or set aside the award, and you say it's not doing any of those things when it's dismissing the preliminary issue.
Correct.
So what is it doing? Exercising powers under the CPR? Or you say it's exercising powers under Section 73, which are implicit, because they're not explicit.
They're not explicit. They're not explicit. But you make the application under Section 73. Our application was made pursuant to Section 73 in the context of the Section 67 claim.
The court has power, I suppose, in the sense that it has to apply Section 73. It has to deal with your application.
That is my submission, that it's an application under Section 73 and the court's exercising its powers pursuant to Section 73, even if it's not specified, and that may or may not lead to a decision under Section 67 depending on its outcome.
Yes, I see. Thank you.
So you say a decision that a party has not lost the right to make a Section 67 challenge is simply that, and it begs the question whether the Section 67 challenge will succeed.
Yes.
It simply has not lost the right to make it,
Yes.
and therefore it's not a decision under Section 67. Is that the essential argument?
Indeed.
Okay. Where next?
So that's all I was going to say about the cases and policy and the language. I've addressed those matters as best I can put forward. Just a few sweep-up points in response to some of the points made by NEOC, many of them which I believe I've covered, and we'll just check through the list. Now, so NEOC say, for example, paragraph 8.1 of their skeleton, that the court decided that NEOC's claim could proceed to trial, and this was a decision under Section 67.4. So in other words, their position is a decision along the way is a decision for the purpose of Section 67. That is the debate I've already had with the court, and I'm not going to repeat the points I've already made. In response to that, we say it's narrower than that. Now, I suppose what it's worth the court perhaps considering is the implications of NEOC's position, which it seems to me, if that's right, then as Lord Justice Nugee has put to me and was postulated in the Manchester City case, then decisions along the way to the determination, including case management decisions, decisions to permit fresh evidence in a Section 67, whether or not witnesses are to be called to give live testimony, I suppose security for costs, any of those could potentially be decisions along the way, and therefore court on that analysis. And we question the for the reasons I've given, we question the policy behind that. Now, it's also said that Crescent's interpretation leads to procedural incoherence on the basis that in a case of a partially successful Section 73 application, it will not be clear who has won or lost. But in my submission, that conflates a situation where a Section 67 applicant raises one jurisdictional point and where it raises more than one jurisdictional point. If the Section 67 applicant raises one jurisdictional point, that there is effectively one application before the court. If waiver applies, the application will fail in its entirety. If it contains two jurisdictional objections, then one has to, in my submission, for the purpose of Section 67, consider each objection separately and whether waiver has or has not barred any of these objections. Because to test it another way, each objection becomes a separate point for the purpose of permission to appeal. So each objection that is put forward may or may not give rise to a waiver decision or not. So a decision under Section 67, so you just take it by objection. That's my answer to the procedural incoherence. It's also said that a failed summary judgment application would undoubtedly be a decision under Section 67(4), and the same applies a fortiori to a failed Section 73 application. Well, obviously, a summary judgment application is made under Part 24, and I submit that the same analysis applies. It may give rise to a decision under Section 67, it may not.
But if the summary judgment succeeds, the application succeeds, then the Section 67 application is dismissed and that's an end of it, and therefore you need permission from the judge. But if the summary judgment application fails, are you saying there can then be permission granted by this court if the judge refuses?
On my analysis, yes. Because it doesn't dispose of the application under Section 67. Now, just going back to the policy under my final submission, I did seek to make some observations about the importance of the Section 73 policy as a freestanding point. I just want to draw your attention to how those policy considerations are highlighted, and forgive me if I'm going to make a forensic point, on the facts of this case for the reasons set out in Dorowski 1, and we don't have to take it up, Supplemental Bundle, Volume 3, Tab 11, at paragraphs 31, 32, and 52. The first point is it's taken Crescent 13 years for Crescent to get to a remedies award, and we say that's because of serial resignations, obviously, by NEOC-appointed arbitrators, and various unsuccessful challenges to arbitrators. Iranian law has dominated the proceedings, but the points on construction that you are concerned with on the summary judgment were never put before the arbitrators. And NEOC, the award debtor, has not honoured any part of the award, even that part which is not the subject of the Section 67 challenge. Now, I say the proceedings are continuing, as I already told you. So the position is, under Section 73, there's a strong policy, I submit, in favour of the award creditors being the innocent party. And in my submission, the facts illustrate that point to some extent. My lord, those are my submissions.
Yes, all right. Well, I think it would. I don't think we're likely to give an off-the-cuff decision on what is quite a tricky point. So I think the most convenient course is if you go on to deal with the remaining points, which I suppose are whether you should have permission,
yes,
if we're able to give it, and then the merits of the point. As I said, this would be dealt with in a rolled-up hearing, and then Mr. Bailey can deal with it all compendiously in whatever way he sees fit.
Now, just on the question of permission to appeal, can I make 4 opening observations before I get into the meat of why I respectfully submit permission should be granted? First, the court itself recognised that the question of whether NEOC had put the construction contention before the tribunal was close to the borderline. That's paragraph 38 of the judgment, Core Bundle 1, volume, tab 11, page 125. Second, the construction contention now being advanced was never expressly articulated, and none of the alleged Iranian law legal principles that are the foundation for that construction contention were ever put to the tribunal. That much is common ground. Third, the construction contention was never addressed by the tribunal in the remedies award. We've seen the paragraph 555, which in my submission is a remarkable state of affairs. It means, and this is part of the nub of the point, that despite the tribunal being the chosen forum for the resolution of disputes and having competence under the Arbitration Act to decide questions of jurisdiction, albeit not being the final arbiter, it never had the opportunity to exercise competence. A jurisdictional rehearing under Section 67 is intended to be a rehearing of the exercise of competence. Fourth, Section 73 enshrines, as I've already said, a fundamental principle of international arbitration being that of waiver. And it is at least of some note that there is no Court of Appeal authority on Section 73. So with those four preliminary points, can I get to the meat of my application for permission to appeal? And I want to divide up my submissions into the following strands. What is the proper meaning of the term ground for jurisdictional objection, which has to be made before the tribunal for the purpose of avoiding waiver? What does a party have to do before the tribunal to make or thereby bring forward its ground for jurisdictional objection and avoid waiver? And where did the court, in my respectful submission, go wrong? If I may divide it up, and I'll try and be relatively brief, and then we can see where we get to. First,
sorry, just to clarify, these are, I mean, these sound like, and it's probably what you're intending to do, the submissions on the merits of the point. I mean, I don't think we want to have it all gone through twice.
Oh, I see. Okay. That's fine, but can I give you an overview of my point?
You've made your sort of overview of why permission in your 4 points.
Okay. I'm going to get to the meat.
I don't know whether there's anything more you want to specifically say about that, but maybe best.
Forgive me. I had misunderstood what
yes. All right.
your order was anticipating. Can I give you a brief overview though of
yes,
these things?
By means.
Let me try, because I'm not going to come back to it.
I just didn't want you to, as it
Go
were,
through twice.
make your points once and then make them again under merits.
I won't make them twice.
Okay.
But maybe I'll start by making my propositions and points, and then seek to make them good on authority and the statutory language.
That's absolutely fine.
Now, the starting point on which I do not understand there is any dispute is that the ground for jurisdictional objection within the meaning of Section 73 encompasses the underlying basis or because for the challenge to the tribunal's substantive jurisdiction. A party, therefore, may have one or more than one ground for jurisdictional objection, and as I'm going to show you in the authorities, for the purposes of Section 73, each ground has to be brought forward before the tribunal if it is not to be waived. And the authorities on this, which I will take you to, are Zestafoni and Prime Trade. Now, so grounds for objection, just to forgive me for being basic, but grounds for objection may include a party did not consent to arbitrate at all, the party's consent was subject to coercion or fraud. Those are different grounds. A formality requirement was not complied with. The subject matter is unarbitrable. As a matter of construction, something is not within the scope of the arbitration clause. Those are all different grounds for objection. Each one has to be brought forward to avoid waiver. In my submission, on Section 73 on established authority, at first instance at least. Now, second, in terms of what a party has to bring forward, and this is really at the nub of my permission to appeal and appeal application, in terms of what a party has to bring forward, what a party has to do to bring forward a particular ground for objection, for the purpose of Section 73, both as a matter of language and the underlying statutory policy of fair dealing and openness, and I'll take you to the cases on fair dealing and openness, and preventing a party from keeping a point up its sleeve for later deployment, in my submission, it must expressly articulate the underlying basis for the objection to jurisdiction in a sufficient manner such that there is a reasonable and fair opportunity for the other party to respond to it and for the tribunal to determine it, exercising its competence. I would further submit, as prior case law illustrates, which I'm going to come to, for the purposes of answering the question as to whether whether it's been articulated in a sufficient manner such that there's a reasonable and fair opportunity, the question is answered by looking not only at the objecting party's pleaded case and submissions, but also how it is responded to by the opposing party and how it is dealt with in the award. And prior cases, as I'm going to in my submission, illustrate this point. Now, put another way, as I've already said, one does not get a rehearing of a point that was not fairly put to the tribunal for determination, because that is not a rehearing. Now, and of course, in Dalla, the court, in the House of Lords decision in Dalla, the court, of course, observed that the tribunal, and we can this is at paragraph 158 to 160 of Lord Savile's judgment, which is to be found. We don't have to take it up because it's a fairly trite point. Volume 1, tab 11, page 341. That the tribunal has competence to determine their own jurisdiction, but cannot be the final arbiter of their jurisdiction, and their ruling cannot bind the court. The court may nevertheless find it useful to see how the arbitrator dealt with the questions. So that presupposes that on a section 67, or the equivalent under the New York Convention, that you have the tribunal's reasons, because you always hear when you talk about section 67 rehearings, that whilst the court is not bound by the reasons of the tribunal, because it's exercising final competence and it's a rehearing, it will look at them with interest. So, and that is where I submit is something which in my submission has gone wrong, in my respectful submission has gone wrong here, because the court looked at Neox's pleading, which we're going to come to, and talks about what could be implicitly extracted from it, and we can have a debate about whether it's correct. But it didn't go on to consider how Crescent understood what was being put forward, Neox's response to what Crescent understood to being put forward, or how the tribunal dealt with it. And in terms of asking the question whether it was fairly put for determination, in my submission, those must be key components. And as I say, I'm going to take you to cases on that. So, if I can just summarize what I submit and I say this very respectfully because Mr. Justice Butcher is a formidable judge, and but I say this with great respect. Can I identify what I submit are the errors in legal approach that was adopted? So the first thing I say is that unlike in the Balochistan case and other cases that I'm going to take you to, the court did not ask itself the question as to whether the construction contention had been fairly put for determination by the tribunal, but instead asked itself whether it was implicit from Neox's pleadings, and therefore didn't look to Crescent's understanding of the ground for objection or the tribunal's understanding. We know what the tribunal's understanding of the ground for objection was at paragraph 555. We can take out paragraph 555. So that's core. I know your lordship and ladyship already have it. Core bundle 2, tab 17, page 342. So what? And I'm going to take you to this. I'm going to show you. I'm so sorry. Core bundle 2, tab 17, page 342. Now, obviously, the court was not dealing. Sorry, the tribunal was not dealing with construction at all. It was dealing with a point of, well, what it called, it has no capacity to resolve any disputes. What I've called a trespass to privity point. What I mean by that is what was being said and what Crescent understood was being said and what the tribunal understood was being said is that you can't determine disputes involving a third party because another tribunal has jurisdiction. And our answer to that was, we're not asking you to resolve disputes. We're asking you to assess with res judicata effect. We're simply asking you to determine the consequences of breach under this contract. It's not the same as determining dispute because there's no question of interfering with the jurisdiction of another tribunal with any res judicata effect. And we cited Mustel and Boyd on the fact that this concept of inarbitrability, that it's inarbitrable, that you can't, it is misconceived, but tested another way, whether the arbitration clause was broad or narrow, this point would remain. Which is that on their case, as we understood it, they're saying that you're trespassing on the jurisdiction of another tribunal because you're resolving disputes between, in a case of ABC, between B and C, which is why the tribunal called it misconceived in this paragraph. The argument is misconceived, that's the last sentence. However, CGC is not inviting the tribunal to resolve any dispute between CGC and CNGC. In the context of a dispute between CGC and NEOT, CGC is inviting the tribunal to reach a conclusion that CGC is liable. So we say that was a distinct point as to trespass to privity, res judicata, determinations with res judicata effect, which is why the tribunal called it misconceived, because we made the submission that this was a misconceived point, and NEOT didn't respond saying, oh, you've misunderstood our point, it's actually about construction and the scope of the arbitration agreement. And that, in my submission, as I'm going to seek to develop, it's a distinct point, because whether or not the arbitration agreement was narrow or broad, the point would remain on this part of the case that you're trespassing by determining disputes involving B and C.
I'm not sure why the way in which the tribunal deal with the point is critical. I can understand the argument that the objection has to be raised in sufficient detail for the arbitrators to determine it. Mm-hmm. It's a bit hard to get that from section 73, but I think you can get it from section 31, which says that where a point is raised, the arbitrators can either deal with it in an award on the merits, or in an award as to jurisdiction, or leave it to the court to deal with under section 32, from which it is perhaps implicit that the point has to be raised in sufficient detail for the arbitrators to decide how to deal with it.
Yes.
But surely, in order to see whether it has been, one is looking at what the objecting party is saying in its pleadings or submissions or wherever.
Of course.
And the fact that the arbitrators don't deal with it in the award, or don't deal with it very fully, might be because they haven't fully grappled with it, or because they think they don't need it, or for all sorts of reasons. But if it's there in the submissions, it's there.
Well, I can take that point on board fully, but if the tribunal has failed to deal with an issue that has been put, there's obviously an issue as to failure to deal with an issue, procedural regularity under Section 68. Of course, a tribunal can deal with a point succinctly and deal with it in a cut-through way, and so it cannot be said to be determinative of the question of whether it was sufficiently put. I accept that as well. But what I do say is that it's not sufficient to isolate NEOC's pleading on its own without reference to the way Crescent understood the point and how it evolved to be satisfied that it's been sufficiently put and a point has not been kept up the award debtor's sleeve. That's what I do say that. And in terms of the genesis of...
Well, that's quite
nuance.
Rhetorical language, but since NEOC seemed to have been taking every conceivable point, that's what you say anyway, one would rather think that if they thought of this point, they'd have taken it.
You would have thought so, and the question is why?
And it may be your ultimate argument, if we ever get to the merits, will be, well, if this was such a good thought, you'd have thought of it, good point, you'd have thought of it earlier.
Would have thought about putting it in the arbitration.
Yeah.
Yes.
Yeah. So it's not really keeping something up their sleeve for later, although...
Well, it depends on how you define keeping up your sleeve. The way I define it is one whether you could or should, with reasonable diligence, have put it forward under Section 73. Yeah,
well, I think you would normally think of somebody keeping something up their sleeve deliberately, not by oversight.
Yes, but for the purposes of Section 73, it's not a test of whether, as we've already looked at the DAC report and the way Section 73 is about whether could and should with reasonable diligence. So it's not a test of deliberate, albeit...
and that's just it's the language of keeping it up your sleeve suggests something slightly improper and deliberate. But
understood. Understood. Now, so, but what I do say, therefore, and the court, so the court in my submission didn't ask the question sufficiently broadly. What it did and if we go to the judgment, at paragraph 38.3, what is suggested here, and we'll have to go to the paragraph because I take issue with the conclusion in any event, but what is said in 38.3 on page 126, the last 3 lines, the paragraph does at least implicitly put forward the case that a claim as to whether and if so, to what extent CGC may be liable is not one which arises out of or relates to the GSPC itself. So I say to seek to implicitly extract, it shouldn't be the test, because then one starts getting into questions as to whether, where does that end? Because obviously, in this case, as we're going to see, what they simply said was, we have a subject matter ratione materiae objection. They focus on the trespassing, they use the word trespass several times, to the jurisdiction of the tribunal. And what is the point that they were putting before the tribunal for determination? And I say implicitly is not the test. And I also say that one does need to look at how it was understood. Of course, if a person obtusely misunderstands the point, and one is satisfied that it's been clearly put, that might be a different situation, because then that's a failure to deal with an issue. But one still looks in my submission, because, and here, what is being said, it was implicitly put, i.e. not expressly. And that begs the question of how it unfolded, what Crescent understood, and what the tribunal thought, or at least as a matter of whether it was fairly put. And your lordship said that might be the genesis, or the underlying basis for that might be section 31. The cases, as I'm going to show you, have developed it on the basis of a principle of international arbitration, of fair dealing between the parties. Now, so in my submission on the court's analysis, there were actually two grounds of objection: a construction contention and this distinct point about resolving this trespass, what I call the trespass to privity point, about resolving disputes in a res judicata fashion. Whereas in fact, there was only one. Now, in terms of why, just to foreshadow the point, and then I'm going to develop all these points a bit more. In terms of why I submit that Iranian law could not simply be treated as argument in support of the construction point, is this. In my submission, both as a matter of, and I'm going to show you this, but both as a matter of English law and general international arbitration principles, the principles of interpretation under Iranian law, as contended for now, are so diametrically opposed to English law and international arbitration that without drawing them to the tribunal's attention, and in the absence of any express articulation and elaboration of the narrow construction point, in my submission, it was impossible for either Crescent or tribunal to know that this construction point was in fact being advanced. On the contrary, it was Iranian law that had to drive the contention. So the absence of Iranian law, in my submission, was an extremely telling factor, and it wasn't just pure argument. And as I'm also going to show you, in fact, in a related arbitration which was then put into this put to the tribunal here, New York were invoking conventional arbitration construction points and Fiona Trust. And so that, again, begs the question as to whether or not this emasculated construction was being put for determination. So, with that overview, can I turn to the language of section 73 and the question of making the objection? So, if we go to volume 5, tab 54, at page 1317. So 73(1) provides, if a party to arbitral tribunal, to arbitral proceedings takes part or continues to take part in the proceedings without making, either forthwith or within such time as allowed by the arbitration agreement of the tribunal, any objection that the tribunal lacks substantive jurisdiction, that's the one we're concerned with, he may not raise that objection later before the tribunal or the court unless he shows that at the time he took part or continued to take part in the proceedings, he did not know and could not with reasonable diligence have discovered the grounds for the objection. And what the courts have interpreted Section 73 to mean, when it talks about making the objection, it means making the grounds for objection, as I'm now going to show you. So he has to make the grounds for objection, and the reason why the courts have said this, the rationale for this, as I'm also going to show you, is the policy of openness and fair dealing. And the same policy I submit, as I'm going to show you in a moment, the same policy of openness and fair dealing, which requires the party raising the jurisdictional, making a jurisdictional objection, have to advance the grounds for objection, must necessarily, in my submission, inform what bringing forward the grounds for objection means, because otherwise the rationale for that requirement to bring forward the grounds for objection would itself be defeated. Let me try and explain what I mean by that. Can we look at two cases? The first is the Zestafoni, which is Mr. Justice Coleman's decision, Legal Authorities, Volume 2, Tab 25. So, just in terms of the fact pattern, the question which arose, and you can see this at paragraph 60, the question that the award debtor wanted to raise on the Section 67 jurisdictional challenge was, and we'll see here, it was submitted on behalf of Zestafoni that even if there was a concluded and otherwise binding agreement to appoint Mr. Cannell as sole arbitrator, it is unenforceable in the English courts as a matter of public policy, because under the law of Georgia, contracts containing all arbitration clauses need to be specifically authorized by the Georgian ministry. Now, that hadn't been raised, that point, the basis for the objection to jurisdiction, which is you require authorization, hadn't been raised before the tribunal. What had been raised before the tribunal wasn't this sort of illegality point, but that the arbitrator had not been validly appointed because the contractual agreement between four parties provided for a 3-member arbitral tribunal, and when a dispute arose between two, they could not validly agree to an ad hoc appointment of a sole arbitrator. So that was the point that had been raised before the tribunal. So paragraph 61, you'll see that the complaint was, little 1, the point was never taken before the arbitrator. And this is, and the question then arose whether Section 73 applies. And so Mr. Justice Coleman at paragraph 63 refers to the Rustal trading case and explains some of the rationales behind Section 73. The subsection as a whole is designed to ensure that a party who believes he has grounds for objecting to the constitution of the tribunal or the conduct of the proceedings raises that objection if he wishes to do so as soon as he is or ought reasonably to be aware. He is not entitled to allow the proceedings to continue without alerting the tribunal and the other party to a flaw which in his view renders the whole arbitral process invalid. And then it goes on to say, there's however a more fundamental objection of principle to a party continuing to take in part, while at the same time keeping up his sleeve the right to challenge the award if he is dissatisfied with the outcome. The unfairness inherent in doing so is of course magnified by if the defect is one which could have been remedied if a proper objection had been made at the time. Now, going on, Mr. Justice Coleman actually extends those observations in paragraph 64. I would go further. The principle of openness and fair dealing between the parties to an arbitration demands not merely that if jurisdiction is to be challenged, the issue as to jurisdiction must normally have been raised at least on some ground before the arbitrator, but that each ground of challenge to the jurisdiction must previously have been raised before the arbitrator if it is to be raised under section 67. And he says, just a little bit further below, were it otherwise, the policy of the subsection could be frustrated by introducing at the last minute grounds of challenge not hitherto raised, and thereby potential causes of delay and disruption of the application to the prejudice of the opposing party. So this is all very familiar ground to the court, I realise, but it's the policy of openness and fair dealing which led the court to say that each ground of objection has to be put forward. Openness and fair dealing, that was the basis. And then, apologies if I'm taking this too slowly. I will speed up, I can assure the court. So the court, the court rejected it under section 73. Now, in prime trade, Mr. Justice Aiken then used Mr. Justice Coleman's observations and applied it specifically to the language of section 73, which was the point I was trying to make, but probably inelegantly. And let me just very briefly take you to the relevant paragraphs of that, which is in volume 3, tab 40. Now, just to give you the facts, so the ship owners had commenced arbitration against prime trade on the basis that an explosion had occurred on their vessel due to dangerous cargo shipped by prime trade. And the ship owners claimed that prime trade, although not an original party to the bill of lading, became bound by the arbitration clause, and it raised on two bases. Being prime trade became the lawful holder of the bills under COGSA, and prime trade had made a claim within the meaning of a separate provision of COGSA, and therefore became subject to the same liabilities, and therefore was bound. So it put forward two grounds of objection before the tribunal. And the prime trade was held by the tribunal to be both lawful holder and had made a claim. Now, picking up in the judgment at paragraph 59, so what is said here is clear that the intention behind, this is page 887, behind section 73 is to ensure that a party objecting to jurisdiction who has decided to take part in the arbitral proceedings should bring forward his objection in those proceedings before the arbitrator. He should not hold them in reserve for a challenge to jurisdiction in the court. I agree with Coleman J. that this intention reflects a principle of openness and fair dealing between the parties, who may or may not be bound by an arbitration clause. I also agree with Coleman J., and this is the important point for my purposes, therefore, that to fulfill this intention in accord with the principles of the words, any objection, and that objection in section 73 must mean any ground of objection and that ground of objection. So, what's being said, where it talks about making an objection, you have to make the grounds for objection. In my submission.
Well, that's a bit of a stretch simply on the language of section 73, but I suppose you can rely on the interpretation principle in section 1.
You can.
Which maybe helps you
a bit of a stretch.
Along the way.
It's a bit of a stretch, but you can rely on the interpretation principle of section 1. I think the other part which the cases have relied upon is if one goes back to section 73, if I may find that, you'll remember that at the end of it, in the part of the due diligence part, it refers to grounds.
Yes.
So I think what they've done is also rely on the fact that there it's talking about the grounds of objection, and they've inserted it where it isn't specifically referred to. Because if you could, with reasonable diligence, have discovered the grounds, then logically you ought to put forward the grounds. Or at least that's my added gloss to the basis on which the courts have said objection, and that objection means grounds for objection.
Yes.
But I take your lordship's point, but they relied on the principle of fairness and open dealing, which one could use Section 1 for the purposes of.
Yes.
For interpretation purposes.
Yes, I understand.
Now, can I then look at can we just briefly, in this context, look at the observations of Lord Savile and Dalla, just to give you the references, and then I want to look in a little bit more detail as to how other cases have dealt with the question of whether or not the grounds of objection have been made. I of course appreciate the court, this is where the court rejected this point, it's not bound by any of these decisions. They're just indicators for the court to give consideration to. So Dalla, Volume 1, Tab 11, because this is a point, or I think, of difference between my learned friend and I as to where you draw the line for the purpose of a rehearing. So if we simply go to paragraph 160, well, 158, you'll see at 158 there's the reference to the doctrine of competence, page 341. So we can see the reference to a tribunal can exercise competence on the question of jurisdiction of 158. We can see at 159 from letter F. An arbitral referring to the DAC report, an arbitral tribunal may rule on its own jurisdiction, but cannot be the final arbitral jurisdiction, for this would provide a classic case of pulling oneself up by one's bootstraps. In my judgment, therefore, and this goes back to the rehearing point, the starting point cannot be a review. Indeed, no question of review arises at any stage. The starting point is an independent investigation. The findings of fact made by the arbitrator and their view of the law can in no sense bind the court, though of course the court may find it useful to see how the arbitrators dealt with the question. That of course presupposes, in a sense, that the point was before the tribunal, which could then exercise its competence to address the point, which in a sense is the purpose of section 73, which is if you haven't put it to the tribunal, so that the tribunal can exercise competence, then you can't put it before the court on a rehearing. That's not a rehearing, that's a hearing, in my submission. And then that begs the question as to where the line is to be drawn. So, can I take your ladyship and your lordships to a case which I submit the court departed from in terms of approach, accepting the submissions of my learned friend, which I submit is one of the key points in this case. So this is the province of Balochistan case, a judgment of Mr. Justice Knowles, Volume 4, Tab 41. So, again, I'm going to have to give you a little bit of the factual framework in order to understand what happened. But basically, a Section 73 waiver happened in this point, in this case. So, if we look at the left-hand column on page 902, Tathan had commenced ICC proceedings against the province of Balochistan for refusing to provide a mining lease. The province, in response to the ICC proceedings, commenced proceedings at the Supreme Court of Pakistan, which handed down a judgment to the effect that the agreement was illegal and void and did not confer any rights on Tathan. So a jurisdictional objection, and we can see this on the right-hand column at the top, was taken before the tribunal, relying upon the Supreme Court judgment on the basis that the tribunal, there was an issue estoppel arising out of the judgment. You'll see a reference to an issue estoppel. So the point being taken is your issue is stopped from departing from the Supreme Court's ruling, which was declared that the agreement was void. And the tribunal got around that by saying, well, separability applies, and that doesn't impugn the arbitration agreement, which is a distinct agreement. Now, on the Section 67 claim, and we can see this on page 903, and you'll see this in at the top of 903. What they were then saying on the Section 67 is not only the res judicata issue estoppel point, but they then sought to amend the arbitration claim to contend that the arbitration agreement was void due to corruption, i.e. they were directly themselves impugning the arbitration agreement. And the question was whether this was a new ground of objection. And the court held that it was. And I want to pay close attention to the court's extraction of principles in this case, and where I submit there was a small but significant departure by Mr. Justice Butcher. So if we start in terms of paragraph, and I can understand why, but I submit that actually there shouldn't have been. Now, if we start at paragraph 100, this was the submission made by Lord Goldsmith as to the principles under Section 73. Lord Goldsmith, at paragraph 100, says, Section 73 requires an objection as to jurisdiction to be made fairly and fully so that the relevant tribunal can rule on it. It requires a party to raise an issue as to jurisdiction. To mention is not enough. The real question, they argue, is whether an issue was properly put to the tribunal as denying jurisdiction. Whether it was raised, put forward and argued, with the tribunal having the opportunity to answer it. Now, I'm afraid you can see resonation between the way it's been put by Lord Goldsmith and what I've put, because unfortunately I don't think I could put it better than him. But I've essentially, maybe not quite as fully, because he says made fairly and fully. I'm not contending for it being made fully so that every strand in the argument has to be, as long as it's made fairly and adequately so that it can be responded to and dealt with by the tribunal, albeit, of course, as your lordship has put to me, well, the tribunal may mess up, or they may decide to deal with it in a very short fashion. And that can happen. So, in terms of principles, some of them we've already picked up on, but we can see at paragraph 101 the reference to Mr. Justice Morbick and Rust Oil Trading, which we've already looked at, and so I'm not going to just repeat what I've said. We can see, and forgive me, I am coming to the punchline in short order. Paragraph 102, we can talk, is reference to the principle of openness and fair dealing. And then, after dealing with all the cases, at paragraph 112, sorry, that's not at paragraph 112. If we then go on to 106, and this is where there was a slight change in the test which Mr. Justice Butcher put forward. In 106, you can see a reference to Concola Copper. Now, just to be clear, and this was the point that my learned friend made to Mr. Justice Butcher, that was an extension of time case. It wasn't a Section 73 case. And what was put here, which was adopted by Mr. Justice Knowles in the context of Section 73, the parties are entitled to know the specific grounds which are to be advanced in a challenge to an arbitration award, not only because they must know the case to be met, but also because they should know the extent to which what would otherwise be a valid award is challenged. One of the objectives of arbitral proceedings is to achieve the speedy determination of disputes. It's very important that the time requirements prescribed by the Act are strictly complied with. Now, if we then, so Mr. Justice Knowles adopted that time extension point in the context of Section 73, as I'm going to show you. And I'm going to show you where Mr. Justice Butcher departed. So if we go to paragraph 110, this is Mr. Justice Knowles' summary of principles. The fundamental principle or policy is fairness and justice in the sense of openness and fair dealing between the parties. 2, there's also a concern to avoid waste of time and expense. 3, the issue as to jurisdiction must normally be raised at least on some grounds. In addition, 4, each ground of challenge must have been raised if it is to be raised. By this is meant the irregularity that the party considers renders the whole process invalid. Now, just pausing there, this was properly corrected by Mr. Justice Butcher because, of course, 73 is not concerned just with procedural irregularities under Section 68, but also substantive jurisdiction issues under Section 67. So this, to just refer to it as a irregularity is in error, so to speak, as I'll show you in his judgment. It is wrong to be prescriptive or try to lay down precise limits in the abstract for the meaning of the phrase grounds for objection, but is usually easy to recognise in particular cases where a party is attempting to raise a new ground. The grounds of objection should not be examined closely as if a pleading, but broadly or adopting a broad approach. The fact that different and broader arguments are raised or new evidence is put forward does not mean there is a new ground. But 7, this is not to suggest a relaxed approach, especially bearing in mind 1, that's the principle of fairness and open dealing. The other party must know the specific ground which are to be advanced in challenge to an arbitration award, not only because they must know the case to be met, but also because they should know the extent to which they would otherwise be a valid award be challenged. Now, if we compare that with Mr. Justice Butcher's judgment, in Core 1, tab 11, at paragraph 36 on page 124, you may want to have both open. So points 1, 2, and 3 are adopted verbatim. So is point 4. so is point 4, say that you'll see that the reference to irregularity in this context is changed to objection to jurisdiction. And then in 5, it's maintained. 6 is maintained. Now 7, this is the difference. This is not what Mr. Justice Butcher says. This is not to suggest an unduly relaxed approach, especially bearing in mind subpara 1. The substance of each ground of objection relied upon should have been communicated to the other party. So because of, there's a slight watering down, you may say it's not material, but what's been said in paragraph 7 of Mr. Justice Knowles is that the other party must know the specific grounds which are to be advanced and challenged to an arbitration award, not only because they must know the case to be met, but also because they should know. So there's a specific slight narrowing there, and on that basis, it would appear, reading between the lines, that in Mr. Justice Butcher's view, that it was sufficient, it was implicitly put forward, and the question as to whether Crescent knew the case that was being put was not asked or answered. Of course, your lordships and your ladyship may respond to me after we look at the pleadings in this case. Well, you, Crescent, missed what was there. And if you answer the question that way, then I suppose if we get to this point, then my appeal fails.
Is the question then whether Crescent and the tribunal knew what was being said, or whether they objectively, reasonably should have done?
I think objectively, reasonably should have done is a fair way of putting it.
So their actual response then is perhaps evidence of what a reasonable person.
Yes, it's not determinative, and I'm not suggesting it is determinative. If I've said otherwise, I apologise.
Yes, I see.
I didn't mean to say it's determinative, but what the case is, what one of the cases says, well, in working out whether it's been put, let's look at all the pleadings and how it's dealt with in the award. That gives us indications to answer the question of whether it's been fairly objectively made.
Well, I can see the point that if the principle is one of fairness, then it's legitimate to ask what somebody ought reasonably to have appreciated.
Yes. Which, at least one would expect, one would therefore look at the response and so on. And of course, that part of the analysis is not there in Mr. Justice Butcher's, in my respectful submission, is not there. I, of course, was making all those points before him. So
there's a distinction then between what somebody ought reasonably to have, or there may be, between what somebody ought reasonably to have appreciated at the time, and whether, with hindsight, knowing now what the point is, you can see that it is implicitly there.
exactly.
That's the essential point you're making, isn't it?
Yes.
Yes, I follow.
And that's the critical point. Forgive me for not having been able to
No, I
identify
got
it
there.
as
I got there
clearly
in the
as
end.
you have, my lord.
Yeah. Okay, no, I understand. Thank you.
So just to be clear, what I do say about this little paragraph 7 and the idea that there's an objective standard, and I say that's implicit in the fair dealing approach, that it should be objective, and it doesn't matter in my submission that the Concola Copper case for example, was an extension of time case, because in my submission it's the same point should apply under Section 73. So if we just carry on with how the court approached it, bearing that in mind in terms of applying those principles to the facts, if we pick up the judgment at paragraph 189 at page 940. Paragraph 1.
I don't think it can be paragraph 189.
Page 940.
In the
Sorry.
Oh, sorry,
I'm so sorry.
We're in the authority.
Back to Balochistan.
Ah, right.
I'm so sorry.
No,
What I mean is, so we've seen
No,
what
that's
principles Mr. Justice Knowles sets out. Let's see how he approached the question in terms of answering whether the ground for objection now being advanced had been put forward. So 189, in my judgment, the essential points for stage 4 are: the ICC tribunal was being asked by the province to accept and apply the decision of the Supreme Court, which was said to include the arbitration agreement was null and void. The ICC tribunal was not being asked by the province to decide whether, independently of the decision of the Supreme Court, there was corruption rendering the related agreements void. The ICC tribunal made no ruling itself on the question of corruption because no separate arguments or evidence had been put before it. Corruption was not an issue before the ICC tribunal other than as identified above. So, as part of the analysis as to whether it'd been put, the judge in that case did look at how it had been addressed in the award. I do accept what your lordship has put to me, as I've already said, that one has to not treat that as gospel. But again, going back to the objective question, in my submission, it's got to have some relevance. Especially, which I submit is reinforced by the question, the concept of it being a rehearing and the exercise of competence. Now, and just for your information, paragraph 232 and 233 Mr. Justice Knowles grapples with why the two grounds are distinct. He says at 232, the corruption allegation is defined to mean the allegation by the province of Balochistan that the ICC tribunal lacked jurisdiction because, that's what I call the underlying basis, the Shejva and related agreements were void due to the existence of corruption. In my judgment, the jurisdiction issue that was raised before the ICC tribunal by the province was whether the Supreme Court of Pakistan had decided that the arbitration agreement was void. The corruption allegation as defined is a wider and different allegation to the jurisdiction issue that was raised. And one of the points I made in my grounds for challenge was that, in fact, Dr. Mokarami's report today posits a wider challenge than was even being advanced before the tribunal. I made the point that if that report, you perhaps will see this now more clearly, I made the point at 26.3, he said the claim is outside of the tribunal's jurisdiction. The claim, the damages, your lordship may recall that, your ladyship, at 26.3, now, because it was indirect. Now, that point was never put to the tribunal, that the claim for damages was outside of jurisdiction, because if it had been put forward, it would also follow that the indemnities were outside of jurisdiction. because the indemnities are simply indemnities in respect of third-party losses are by definition therefore indirect losses on that analysis, and therefore outside the scope of the tribunal's jurisdiction. It's just belt and braces between claim for damages and indemnity. They're both indirect losses because they arise out of other contracts. But that was never put forward. It was expressly accepted that an indemnity, the tribunal had jurisdiction over an indemnity, which is why I made the point that there was and I'll come to the pleading shortly, why I make the point that it was a much more focused objection that you're trespassing on the jurisdiction of another tribunal by seeking to resolve disputes. It's this concept of resolving disputes which was the issue. Now, so the conclusion, just for the court's note, paragraph 237, although each mentions corruption, these are different grounds. They're not different arguments or evidence. The former requires examination of what the Supreme Court decided. The latter requires examination of whether there was corruption, such as to avoid the arbitration agreement. Now, so that was the conclusion in that case. There's a few other cases that I want to... there's two other cases I want to put to the court, and then I want to look at the pleadings. I know you're probably anxious to just actually look at what we're talking about.
But if I've understood it, in this case, the consequence of each of what were found to be separate grounds was that the arbitration agreement was treated as void.
So the consequence would be the same objection.
So you could say, one way of articulating it is, there's an argument that it's void, and there were different reasons for it, but actually the judge found there were separate grounds. Yes,
but the reason why I say that was the correct analysis, and your ladyship may pick me up on this, is that there are three levels of operation of how this works. There's the objection. I object to the jurisdiction of the tribunal to determine X, Y, and Z disputes, or that's the first thing. That's the objection. The second is the underlying basis. I object because I never consented at all, or the arbitration agreement as a matter of scope is too narrow, it's inarbitrable, or something. Those are the grounds in my submission. Then, to answer your ladyship's question, and this is where we may end up having a debate, there's then arguments. So, for example, which are said to support. So, if you say that the clause is far too narrow, you say, well, look at these words, look at these words, look at Iranian law. You could, in that context, if you have said very fairly and squarely that the arbitration agreement is too narrow, and some of the cases have said this, if you've said that as a matter of construction of the arbitration agreement, it's a condition precedent to arbitration that you do X, that's the basis on which you're objecting to jurisdiction. And then in the section 67, you say, well, and if you, in terms of that construction point that I'm putting forward, have a look at Indian law, which is the governing law. Those are then said to be arguments because you've put forward the basis.
I understand the hierarchy. Yes. I was just making a comment about
I'm sorry.
this case.
So you could say, just to answer your question, so you could say that they are both different arguments for the same.
Well, but that's my point. It's illustrating how difficult that division between the second and the third levels is.
It can be, I suppose. I'm reluctant to accept it too easily, because what Mr. Justice Akins, as he then was, said, it's normally easy to, should normally be easy. It seems to me that if you're putting forward a construction point, it should be pretty easy to see that.
Yes, I'm making a specific argument in point in relation to this
This case.
we've just
Yes.
been looking
No, I see
at,
that.
not the facts.
Yes, but the way I would, in response to your ladyship's point on this specific case, the way I would say, would put it, is that I would say that you, the tribunal, what is being said is you, the tribunal, have no jurisdiction over the dispute. That's the objection. And there are two different points you can take as to the grounds. One is that the arbitration clause has been actually impugned by fraud, and you want that to be determined by the tribunal, or that you, the tribunal, are bound by res judicata determinations of.
Yeah.
So I would put it at a different level of
Okay,
abstraction, but I
see.
take your
Yes.
ladyship's point.
Thank you.
Two other cases, and then I want to get to the way it developed before the tribunal,
Yes.
if I may.
All right. Well, we do need to get to that.
I do. I do, of course. And I'll try and be brief because they're not nearly as important. And so Legal Authorities, Volume 1, Tab 2. This is the AEK case. Now, it's a very simple case. In the arbitration, the contention was that there was an objection to jurisdiction on the basis that the consent to arbitration had been vitiated by coercion. Before the court, an additional point was being run that there had been no consent at all. And if we just pick up on a few paragraphs from starting at 21, so this is pre the kind of more refined formulations that we've seen in prime trade and so on. But it was not disputed the effect of the provision is that AEK are debarred from arguing any jurisdictional point which was not argued before the arbitrator. Mr. Hoyle for AEK submitted that AEK made a freestanding submission to the arbitrator that quite apart from coercion or other vitiating factor, AEK had not consented to arbitrate. This was denied by each of the respondents who contended there was no such freestanding submission. And then there's an analysis of the defence pleading at paragraph 23. And the conclusion is, in my view, the entirety of the plea proceeds on the basis that AEK accepted they have entered into an apparent agreement to arbitrate on the matters, but they should not be held to that agreement. And then paragraph 24, this is, I suppose, my point. My conclusion as to the ambit of the pleaded jurisdictional challenge is reinforced by the fact that the section of the claimant's arbitral closing written submissions replying to the plea based on lack of consent is concerned exclusively to rebut the suggestion of coercion. Nothing is said to rebut a submission that it never entered into agreement. The fact that in his reasons for rejecting the jurisdiction challenge, the arbitrator nowhere deals with the argument. And therefore, it was held to have been waived under Section 73. And so one final case, and then we will turn to the facts. So the final case is in the same bundle at tab 8. This is Mr. Justice. Oh, I've got the wrong reference. Apologies, 1 second. It's actually tab 1. It's Mr. Sir Jeremy Cook as he is now. A against B, you'll see from the head note on page 1. So in the course of the arbitration, the tribunal permitted the substitution of the original claimant, P, with F, into which P had merged under a scheme of amalgamation approved by the Indian courts, on the basis that F was the successor entity. Now, if we look at paragraph 2 on page 3, you'll see that before the tribunal, the objection was made that the arbitration had lapsed by reason of the dissolution of P because no notice had been given to the transfer, and therefore there was no effective assignment. You'll see that between G and H. But on the Section 67 challenge, an additional point was raised, and you'll see that also in paragraph 2, that the tribunal lacked jurisdictional power under the ICC rules to permit substitution. And so, if we look at Sir Jeremy Cook's analysis at paragraph 53, that's what he says. He starts from the award. The arbitrators made no reference because no argument was presented to them about the effect of the rules. The point was never addressed because no objection was ever made. It's just, again, my point of one, well, we'll at least look at the award and see how it's been dealt with. And so at 62 is the conclusion. And there is one point on 62, if we turn over the page at 17. The only basis on which he challenged the substitution of F as a claimant was that substitution was precluded by the decision of the Court of Appeal. That's the notice point. In its skeleton and oral arguments, he contended that if the tribunal to exercise a discretion to allow substitution, it should be allowed only on terms. In making that submission, it's clear that he was accepting that the tribunal had power to order the substitution of F as a claimant. So what it's saying is it was putting forward, in effect, what the court's concluding is actually putting forward an inconsistent point. And that again goes to the point that if the construction point now being raised had been advanced before the tribunal, the scope of the objection would actually have been different. So, now I won't take you back to the DAC report, because we've already actually looked at it. So, where does that take us? So the key pleadings are all in the core supplemental bundle. So if we begin at tab 9, I'm afraid what we've done in this core supplemental bundle is just to excerpt the relevant bits. So I'm going to give you dates and so on so that you can understand what these documents are. So actually, with apologies, can we start at tab 8? 8 and 9 are actually the same part of the same document, but they're different excerpts from the same document. This is the Respondent's Counter Memorial on Remedies. So this is NEOC's Counter Memorial on Remedies of the 3rd of February 2016. And this is the pleading on which the learned judge relied upon for saying that the construction point was implicitly there. So this is the key pleading. So if we start at page 224 at the bottom, paragraph 30.
Well, can you start at paragraph 23?
Okay. So 23, in making this claim, and that's the claim for damages in respect of the CNGC liability. The claimants are asking this tribunal to determine the existence of CGC's liability to CNGC and its extent, yet it is obvious that the tribunal has no jurisdiction to do this. Now, my submission is that's just articulating the objection to jurisdiction and not explaining the basis, underlying basis of it. And if we then go on to what I was going to take the court to, which is under lack of jurisdiction, paragraph 30 and 31, in reality, by asking this tribunal to award damages to CGC for its liabilities to CNGC, the claimants would have the tribunal assert jurisdiction over a lost profits claim by a company who is not a party to the arbitration clause in the GSPC. In fact, CNGC is a party to a different contract containing a different arbitration clause. And then 31, the respondents submit, therefore, that the tribunals cannot properly hear any claims. To do so would be to trespass on the jurisdiction of another tribunal, which CGC and CNGC have contractually agreed should, and I do emphasize the word determine, because this word keeps coming back in almost every paragraph, and that's why Crescent's response, in my submission, objectively viewed as understandable. But so this is why I call it the trespass to privity point. So you're trespassing on the jurisdiction of another tribunal, and then it's developed in the next tab, which has got the next excerpt from the same document, just to make sure that there's no confusion. And this is from paragraph 113. At page 228. So, paragraph 114 just simply makes the point that CNGC is not a party to the GSPC. And 115, this is a sort of recharacterization complaint. Therefore, as the claimants appear to have understood, any claim with respect to lost profits allegedly suffered by CNGC must be framed as a claim by a party to the GSPC. The respondent surmises it is for this reason that the claimants have not put forward a claim for CNGC's lost profits, but rather a claim for CGC's damages resulting from its alleged liability. Consequently, if this tribunal were to consider such a claim, it would first be necessary for it to determine whether and to what extent CGC is indeed liable to CNGC. This is in essence what the claimants have asked the tribunal to do. And then 117, under the heading Tribunal's Jurisdiction Ratione Materiae, which, just to be clear, my submission is Ratione Materiae. It doesn't actually tell you what the underlying basis of the objection is, and it's not adequate in and of itself. Under Article 22, the tribunal has jurisdiction to rule upon any dispute, controversy, or claim arising out or relating to the GSPC itself. On the other hand, the tribunal's jurisdiction does not extend to making any determinations whatsoever, that word again, and if so, to what extent CGC may be liable. On the contrary, and then it goes on to refer to the separate contract and arbitration clause, which is then quoted over the page. And at 119, as a result, the only body having jurisdiction to determine whether, and if so, to what extent CGC is liable, the only body having jurisdiction is the tribunal constituted under that contract. Now, and then at 120, last two lines, this tribunal, in essence, the tribunal is being asked to go beyond the limits of its own jurisdiction. And just to be clear, my submission, whenever you talk about the going beyond the limits of tribunal's jurisdiction, it doesn't follow that you're making a construction point. There are any number of ways which you can be saying that you're going beyond the limits of the tribunal's jurisdiction. And to trespass, that word again, which is why I call it what I do, on the jurisdiction of the only tribunal that would be competent to determine such a claim. So 122 is the conclusion. In sum, the tribunal lacks jurisdiction. Both ratione personae, since CNGC is not a party, and ratione materiae, since a different tribunal with a different seat, acting under different procedure rules and applying a different governing law, has jurisdiction with respect to any claim arising out of the contract between CGC and CNGC. So they're characterizing the claim for liability from CGC to CNGC is in fact, in reality, a claim between CGC and CNGC that has to be determined by a separate. That's the way I would put it. And can we now have a look at the way Crescent understood the object?
Before we do that,
yes.
If you go back to 117.
Yes, which is the critical part on which the court relied.
It starts off by referring to what Article 22
yes.
does confer,
yes.
which is to rule upon any dispute
yes.
arising out of the GSPC
yes.
itself.
Yeah.
And then it says, on the other hand, it doesn't extend to making any determination
yes.
whether CGC may be liable to CNGC.
Yes.
Isn't that exactly the same point? I know it's now put as a question of construction on the basis of
yes.
Iranian principles of construction.
Yes.
But isn't the substance of the point the same point that is now put on the basis of Iranian law, which is that, look at Article 22, that only enables you to decide disputes arising out of the GSPC. That does not extend to deciding disputes under a separate contract. I mean, that is what is now said, isn't it?
My lord, for my submission is this is not what the core of the meat of the point that is being put, and that's why Crescent respond to it in a different way, which I'm going to show you in a moment. I mean, just quoting the arbitration clause and saying that's your jurisdiction doesn't tell you that your gripe is that it's too narrow to determine, to resolve questions of liability to a third party, because you can equally view this as simply saying that you, the tribunal, can't make determinations, i.e. res judicata determinations. That's for another tribunal. So, in other words, the essence of the point, rather than being one of construction, is one of trespass. As
I understand
yes.
that the argument put in support of this contention is put rather differently.
Yes.
But just looking at 117
yes.
by itself,
yeah.
doesn't that amount to saying Article 22 doesn't give you this jurisdiction?
Yes, but my lord, in my respectful submission, and we may need to have a debate about that, that means that there is no real difference between putting your objection and putting your grounds for objection, because you can always put your objection on the basis you, the tribunal, have no jurisdiction conferred on you by reference to this arbitration agreement. In my submission, that's no more than saying that I have an objection to jurisdiction.
Well, no, there may be other objections to jurisdiction. As you said, you may say, I didn't sign up to this agreement, or my consent was coerced, or all sorts of other things. But say this is the article, it doesn't extend to that, does seem to me to be saying, when you properly understand what the article does, it doesn't extend to deciding the liability under a separate contract. And it is a question of how far down the granularity do you have to go before
yes.
you can be said to be raising the same
yes,
objection.
There is an issue of whether the substance of the underlying basis for the objection has been put. That's the question. And
where did you get that from? You showed us all the authorities.
Yes.
They're all first instance authorities.
Yes.
They all use slightly different language.
Yes.
But they all say, yes, you have to put forward your ground of objection.
Yes.
And where do you get the language you just referred to that has the substance of the basis being put?
Well, I mean, that's even in Mr. Justice Butcher's judgment, and I said that that's at 36.7. But I said that that's too narrow because there's an element of fairness, objectivity, and whether it. I've said that even that's a bit too narrow because, there is a little bit of a danger, if I may respectfully submit, in looking at it now, having heard the whole summary judgment application with the principles as now being put, and this bare assertion here as to what the substance of the point being put there, whether it's the same point or not. In my respectful submission, I understand completely where your lordship's coming in up from, and that's essentially what Mr. Butcher came to the same view as your lordship, which is this was, although close to the border, as he put it, paragraph whatever 38, what was sufficient. My submission is that the key emphasis throughout this was really about trespass and making determinations, and not about the clause as a matter of construction being capable. And
it's another way you might put it is, do you have to read paragraph 117 in its context?
yes,
There is, I think you would say, no hint that the point turns on the precise wording of the arbitration clause as opposed to some other principle.
that is my submission, my lady, and I'm grateful for the elucidation.
I
if
suppose,
I can,
I suppose it might be said that if they had only said what is in the second sentence of paragraph 117, they would have made their objection, but they wouldn't have said anything about the basis for that objection. And in particular, they wouldn't have said enough to enable the tribunal to rule on that objection, because without more, the tribunal couldn't understand it. So, but if one reads it in context, you would say what they say in the succeeding paragraphs explains the basis or the grounds on which they are objecting. Is that?
that is correct, my lord, my lady. But can I make the additional point, which I don't think I've managed to land, if I may put this, which is that the point that I say they were running could be run whether the clause was narrow or broad. This trespass point didn't turn on whether the clause was narrow or broad. Either way, you couldn't determine a loss of profit claim between CNGC and CGC because that was for another tribunal.
Yes. Well, the debate we're having at the moment perhaps illustrates the distinction I suggested earlier between being able to see with hindsight that the
Indeed.
point may be there, and whether it was reasonably apparent from what was said at the time.
And that was the point I was trying to respectfully put as to it's
Yes.
one has to look
All right.
boldly at the
Well, we
paragraph in
proceed.
context. That's
See, I
it on
think
this
is
one.
what you say about that.
We're going to proceed to see what Crescent says about this. So that's in tab 12. And just to give you this is claimant's reply memorial on remedies dated the 25th of April 2016. So what is said at so 61, Crescent is summarising what it understands Neok's argument to be. The tribunal has no jurisdiction to determine CGC's claim arising out of CGC's liability to NGC for CNGC's lost profit. The argument is wrong. It's perfectly entitled to determine CGC's loss under the GSPC by reference to another contract. This is part of the tribunal's mandate to determine the disputes between the parties present before it and does not entail any assertion of jurisdiction over a third party. And then it refers to various examples. The critical point is at paragraph 66 on the next page. This is the Mustle and Boyd point that we've looked at in many different contexts. The logically correct position, as noted in Mustle and Boyd, is that tribunal doesn't exceed its jurisdiction. There's nothing inarbitrable about such an issue, reading from the quote, and the arbitrator commits no impropriety, although his award will have no effect at all on C, nor does he exceed his jurisdiction in doing so, for he is not purporting to act as arbitrator in relation to the contract between B and C, in relation to which he was not appointed, but instead is deciding under the contract between A and B an issue which, albeit involving C, does properly arise under that contract. So, what we understood, as I say, what Crescent understood, was this sort of inarbitrability, or what the tribunal called in paragraph 5.5 a capacity point, rather than anything to do with the breadth or narrowness of the arbitration clause under the GSPC. And
do you engage with the terms of the jurisdiction clause at all in this response?
never.
Okay.
And there's no engagement by NEOC ever with the scope of the arbitration clause. So can we look at respondents, so NEOC's response to this at tab 14. So this is respondents' reply counter memorial on remedies of the 19th of August 2016. And if we pick up on page 239 at paragraph 195, the tribunal simply cannot determine the existence or the amount of the alleged liability because it would require the tribunal to make legal and factual determinations, that word again in my submission, under a different contract, which is not a contract within the jurisdiction of this tribunal. And then they go on to say, at 196, the claimants do not dispute this jurisdiction problem. They seek to sidestep it by now reframing the claim. So what they're saying is you're recharacterizing a claim for lost profits under a separate contract into a claim for a damages liability. And you can't sidestep the trespass to the other tribunal's jurisdiction by doing so. And then at 199, they deal with the various authorities and say, at 199, they engage with them, last three lines. In sum, this was an indemnity case, not a case where determinations were made as to the existence or amount of liability under a different contract. They then deal with Mustle and Boyd at paragraph 200. And they say this authority is not on point, it's taken from a section entitled Arbitrability in Effect.
Is there any reference to Iranian law?
No, my lady, not in the context of construction. And one of the points, I mean, many Iranian law points were made and are made in these memorials, but nothing in this context.
In this section.
They do say, and which the court picked up on, and I don't want to mislead the court.
Yeah.
They do say, and I'll be picked up by my learned friend somewhere, that our references to English law are bizarre.
They say that in 198.
Oh, it's on that page?
Yeah, you just favour it.
Okay.
198.
Yes, the claimants refer bizarrely to English laws.
So I was just wondering whether I'd
That's
seen
it.
that,
That's
and I
it.
wondered whether it was
Yeah.
expanded on.
So that's it. I knew there was somewhere, apologies. Well, I mean, but no principles of Iranian law, no heading about, or no identification of what the scope point is or anything of that nature.
And you told us earlier, I think, that what was said in the Geneva arbitration was put before the
I'm going to show you
English
that.
tribunal. We're coming to that.
I'm just about to, shortly. Well, I'm going to show what was done. I'm going to show what was done, and then you can...
Well, we'll see.
Because it goes back to the question of objectively what could be fairly understood.
Yes, that's why I was interested.
Yes, so
I'm only interested in it if it was put before the arbitrators, though.
But, well, to the extent it was put before the arbitrators and Crescent, there are two elements to that. If it was put to Crescent in the context of this arbitration,
Yes.
the London arbitration, that would be...
All right. Well, let's see what it amounts to.
Let's see what it amounts to. So 202 on page 241. Further, it's borne in mind that in the present case, the parties have no way mandated the tribunal to decide issues arising under the contract between CGC and CMGC. Such issues are both inarbitrable and outside the scope of the tribunal's jurisdiction in these proceedings. And to say something is outside the scope of jurisdiction is, in my submission, not much different to saying you've got no jurisdiction. It doesn't tell you what the point is. It's beyond your jurisdiction. It doesn't take the point any further. Now, so let me then take the Geneva proceedings and then where that came back into the London proceedings. So if we go to tab 18, so this is NEOC's submissions of the 24th of May 2019. Now let me just explain the context of them. So in the London arbitration, the reference constituted pursuant to the GSPC arbitration agreement. In the London arbitration, Crescent's claim was for damages up to July 2014. So, but the contract was for 30 years, and so there was further claims for damages post 2014. Crescent commenced a fresh reference to arbitration for that further future loss. It sought to crystallise its loss up to 2014 before the London Arbitral Tribunal, and then made a further claim by a separate reference to arbitration, the Geneva Tribunal. Now, one of the points taken by NEOC was that this was a matter properly falling within the reference to arbitration already commenced before the London Tribunal. And in that context, so I do say this is more than a forensic point, and I'll explain why. So tab 18, what you can see is NEOC's submissions in support of the notion that it all falls within the first reference to arbitration. It said, secondly, at 85, and closely connected with the first point, international arbitration principles in general, and English law is the law of the seat of the first tribunal in particular, follow and give effect to the strong presumption that parties are presumed to be intend all their disputes arising out of a particular relationship to be determined by a single arbitral tribunal.
Are these submissions made to the Geneva arbitration?
Yes, not to the London Tribunal. I don't want to mislead the court, but I'm going to show you how they then were brought into play before the London Tribunal, if I may put it that way. And so it then, if we go on to 87, it then makes reference to the same point, in effect, one-stop adjudication and all that, by reference to international arbitration principles. So it's taking a position which is obviously inconsistent with the position it's taking today, but the question is whether this was being put to the London Tribunal. Now let me show you the award and what happened. So the London Award, Remedies Award, Core Bundle 2, tab 17, at page 235. So Core Bundle 2, tab 17, page 235. Apologies. I think the relevant paragraph is 175.
Is it the second arbitration?
Yes. So 174 is the background. Okay, so the second tribunal referred to in 174 is the Geneva Tribunal. On 18th of June 2019, NEOC submitted a request for permission to refer jurisdictional questions to the English court, seeking permission from this tribunal to apply to the English court under Section 32, resolve the parties' jurisdictional dispute framed as follows. Did the parties refer all disputes relating to NEOC's liability for any alleged past and future breaches of the GSPC to the first arbitration, therefore giving the first tribunal jurisdiction to decide those disputes? So the same point that it was taking before the Geneva Tribunal, it was seeking to invite the tribunal to submit by way of preliminary question under Section 32 of the Arbitration Act. So, now, obviously, Crescent refused consent, and where it ended up with, and I'm just trying to find the reference, paragraph 1882, is that the tribunal refused the request on the basis of lateness, delay. That's at 1882. But my point for present purposes, in terms of the question of whether it can be said to have been fairly or reasonably put, or however the court wants to, in circumstances where they're making a submission which is diametrically opposite to the submission they now wish to make, that surely, in my submission, has to go into the melting pot of what objectively viewed was the jurisdictional point being taken before the London Tribunal. So, if we can then briefly, and I suppose this will be, I will need to go on for a little bit tomorrow, not very long.
Right. What have you still got left to cover?
So, there's a few points I would like to make on the difference between deploying Iranian law as argument as opposed to being the crux of the point, if I may. I don't think I'll be more than 10 or 15 minutes tomorrow, if I may. Yes. If your lordship is concerned about timing and wants me to cut short, I understand. And I will endeavour to consider it overnight. And
right. Well, if you can do what you need to do in 10 or 15 minutes, then that will give Mr. Bailey enough time to deal with what he's got to cover.
Very good. Can I make my one final point for today?
Yes. Which
is if we go back to, therefore, we were in tab 17 of the course bundle 2. When one looks, therefore, at paragraph 555 of the award, albeit it's not determinative of the question of whether the issue of construction was being put forward as a point to be determined, I do say, again, that it is relevant to see how the tribunal addressed it, and they considered it to be a misconceived contention that it was resolving disputes between CGC and CNGC.
Yes. All right. Well, thank you very much. We'll resume tomorrow.
Look, can I just raise one, just very shortly, which is about the timing, or the time available tomorrow, just in terms of enabling me to plan my submission. Do we have a guillotine at lunchtime, or is it do we go into the afternoon slightly? I hope you don't mind me asking.
If you need to go to some extent into the afternoon.